There are only two jurisdictions that have e-discovery rules in Asia, and they are Singapore and Hong Kong. So discovery, it's a familiar concept to the in legal proceedings, and it's not so in other jurisdictions. So if you look at Asia Pacific, really those countries that are common law jurisdictions would be, as I mentioned earlier, Singapore, Hong Kong, Malaysia, also Brunei, and we can also include India, Sri Lanka, and possibly Myanmar, but I'm not so familiar with working in Myanmar, and Pakistan. So when they're used to the traditional way of conducting discovery, previously was done via paper, changing to e-discovery is not such a challenge. It is where you operate in other jurisdictions which maybe have a different legal framework, such as maybe Thailand, for example, or Indonesia, where the concept of discovery is unfamiliar or maybe it doesn't even exist. Then thinking about e-discovery is a real challenge for clients, but also for the lawyers. It's a concept that's quite unfamiliar to them. One of the challenges that we see is really it's the view from HQ many times where they see the Americas, so North America. But North America has had NAFTA for many years. So you have the United States, you've got Canada, you've got Mexico, you have history there, and it's really seen as a single entity. Even in the United States, though they have many rules and regulations at the state level, it is a single country. So people from HQ in the US or in Europe, for that matter, view Asia as Asia. But the reality is that it's a whole wide variety of countries with different legal jurisdictions. I'm not even referring to different countries or territories, just legal jurisdictions. Take for example, Hong Kong, the special administrative region. It is part of China. However, it does have a separate jurisdiction. So understanding that can be quite a challenge if you're not here within the region. Other issues that parties face many times is where conducting data collection and preservation in some jurisdictions is deemed an investigation, and investigations are conducted by the state. They're not conducted by private investigators. So in Singapore, for example, if you want to conduct digital investigations or rediscovery, you actually fall under a specific act, and you need to obtain a PI license, a private investigator license. So all our staff at iAnalysis have a PI license, well, those who conduct this work. Whereas in countries such as Vietnam, for example, because of its history, doesn't allow private investigations. So we need to go in, when we do our work, we need to explain it in some other way that will ensure that what we do doesn't fall foul of the law. Data privacy is obviously a major concern. Data privacy laws in Asia actually predate e-discovery laws. I mean, Singapore was the first country to have an e-discovery practice direction in 2009. Since then, Hong Kong has its own rules since 2014. But no other country has such rules. Obviously, I'm excluding Australia and New Zealand out of this conversation. But you look at, let's say, Thailand or China, Japan, they don't have e-discovery rules to govern, the disclosure of documents in an electronic format. They do, however, have data privacy. So we now live in a post-Snowden world. And everyone is paranoid. So whenever there's an audit or an investigation, people are already on tenterhooks. But now people are wondering, what is it that you're collecting? What are you collecting it for? I have my privacy rights, etc., etc. Other issues that we see in emerging markets is the BYOD, which is the bring your own device, where companies allow employees to connect their own device to the corporate network. They may pay for the line, however the device is still owned by the employee. So many times what we see is employees holding data on an iPad or an Android device, and then they may leave and join another company for whatever purpose. Then 6 months, a year, 2 years down the road, there's a legal matter and that data is resident on their laptop. So hopefully it's still there, hopefully it hasn't been altered in any way, but if it's not there, then that's a problem that needs to be explained to the court. If you're in a situation where, let's say for example, that person joins a competitor, now they have your confidential data on their personal device and that former employee works for a competitor, that's a big problem. You actually don't have a right to access that device. You need to apply to court many times. Hence why we name BYOD, Bring Your Own Disaster. My view is that either companies should provide a company device and company information shall only be on that, or alternatively they should be looking at some type of management software such as MDM software, where for example all the corporate email, and let's say they might be using some corporate Dropbox or Box.com, whatever it is they're using, and sandbox that. So once that individual leaves, you can just issue a command and it's removed from their personal device.